A will is a pretty standard document in the sense that it has certain standard paragraphs in it. Some wills are more robust than others. Some wills include significant additional sections relating to closely held businesses. Some wills have extremely large sections devoted to tax saving strategies, have extended sections relating to special needs trusts, things like that. But whatever the specifics of a will are, each of them have the types of paragraphs that we're going to talk about. So the first paragraph of most wills is a revocation of prior wills. It says, I revoke all prior documents that I previously signed. This is critically important. And it's critically important to know that the document you have in front of you is the most currently written will. It's necessary to say to your client, have you made a diligent search to determine that this is the most current will that was drafted? You also need to ask your client whether they're aware of any trusts being drafted, separate and apart from the will. This is a document that has testamentary powers. In other words, it allows a last statement about what happens to someone's property on death to be binding, separate and apart from the will. So let's go back to our will for a second. So the will talks about revocation, and then it talks about who are the family members, which is helpful because when you are using a will, you of course need to know who the players are. I'm relying on what the family is telling me, but I sure would like to look to the decedent's words about what the family situation was and who their next of kin were. Perhaps if Jane and Wendy were alone, they wouldn't have told me about Michael at all. Maybe, could happen. So let's see what the will says about who the family is. Then the next section generally talks about paying debts and expenses. The will can be silent on this, and in every respect where a will is silent, there is often state statutory law that controls these various topics. So if the will says it should pass according to the terms of this will, subject to a mortgage, for example, you would expect that provision to be in the paying of debts section. If you don't have that language in there, then you have to look to state law. And we've often been surprised. I've seen estates in my office where the attorney didn't understand that there was a statute that specifically said, if you're silent on the issue, then the real estate travels with the mortgage. And maybe that wasn't what Mama Himmelfarb intended. Don't know. The next section talks about tangible personal property. These are things that you can touch, feel, like jewelry, furniture, furnishings, and it says, I want my tangible personal property to go to these people. Sometimes mom will be allowed to write a written list of who she wants it to go to. That's governed by state law. A lot of what we're talking about today, as you can tell, is governed by state law. And so because this is not just specific to the state that we happen to be in, I'm trying not to be specific about one state or another state's provisions. What happens if the children disagree about tangible personal property? And I can tell you that few things cause turmoil like tangible personal property. I sat on a Sunday afternoon from noon to 7 p.m. with 4 60 to 70-year-old sisters while they divided up the potato peelers in their mother's kitchen. 4 of them, that many hours. It was amazing to me, not that I've not done it before, not that I've not seen it before, but if you don't have a will that has a provision in it that says if they can't decide, either the executor decides or there's a lottery among them, you have a very difficult situation. So I want to look at the will and see what it says about tangible personal property. I also then want to see next section, which is for most people the most important section, which is the residuary disposition. This is the paragraph of the will, and it usually is multiple paragraphs actually, that says everything else, after I've paid my bills, after I've distributed the tangible personal property, everything else goes like this. And so this section, called the residuary bequest, can be divided into multiple parts. In our story, what it says is, I give my residuary estate to Jane and to Wendy and to Michael. But as to Michael, I give his share to a trustee who's going to hold Michael's share for him. And then there's a section later in the will that describes how Michael's share is being held. There's also another section that says, what if Jane or Wendy had predeceased mom? In this will, it describes that the fact that if either of them predeceased mom, which they didn't in our story, but if either of them predeceased, then their share goes to their children. But if they don't have children, what does the will say? The will in this case says it goes to the other sibling. The point of this is it's critically important to look at the will, understand this section of it, how the residuary passes, so that you can explain to the client how the estate is going to pass when it's finally distributed. The next big section of the will, which can be enormous, talks about the powers that the executor has in winding up the affairs of the decedent. Maybe here I'm talking about mom's sock business and what the executor can do specially. She can sell it to Jane, even though Jane's interested in it. She can sell it at a discount to Wendy. She can sell the house. She can let Jane remain there. A whole bunch of provisions that allow the executor to know exactly how she's supposed to act relative to these beneficiaries and relative to this property that the decedent had. The next section is critical to this family and to most others, who has been appointed in the various positions we've talked about. So as I said, the will said in this case, it's going to, that Jane is the executor, but who's the alternate? So we look at the will and we say, oh, the alternate is Wendy. That's how we know. And the second alternate is cousin Fran. Nobody likes cousin Fran. No one's ever going to step aside for cousin Fran. But it's interesting to see who the chain of people are. Then there's also a chain of people to be trustees, the people who are going to be responsible for Michael's inheritance, doling it out to him over time. Interesting to consider, should Michael's trustee be Jane? Does mom want Jane to control Michael's inheritance for his lifetime? Likely that would be a bad family mix and a bad family dynamic. But again, this is information in this provision of the will. And then the will concludes with the section that talks about payment of taxes. Again, beyond the scope of this discussion, other than to say wills generally must have a provision that talks about where tax is paid from. Because if you fail to state where the tax is paid from, you have stated, you've chosen the state's plan, and that may result in unbelievably large unintended consequences. The end of the will requires that it be, and again, this is state specific, but that it be signed in the testator's hand, or at the direction of the testator by someone else, that it be witnessed. Different states require different numbers of witnesses, and then almost every state has what's known as a self-proving affidavit, which is a statement under oath by the witnesses that the decedent came before them, looked over age, didn't seem to be compelled, looked to be of sound mind. Why have that affidavit? That allows the court to know when the person passed, that when they signed contemporaneously, the witnesses looked at the situation and said, he's okay. They said at that time, you have a valid will.